Excellences, Mesdames, Messieurs, nous continuons dans cette deuxième séance d'experts de ce matin. Nous allons aborder la question de savoir comment les normes et principes dont nous avons parlé ce matin sont repris dans les différentes régions et quels sont leurs propres mécanismes et orientations dans le domaine de la justice juvénile. Pour l'Afrique, j'ai le plaisir de passer la parole à Madame Julia Slot-Nielsen, membre du Comité africain des experts des droits et du bien-être de l'enfant, University of the Western Cape, Afrique du Sud. S'il vous plaît, Madame.
Microphone. Is the microphone on? Morning, everybody, and thank you very much to the organizers, Terre des Hommes Foundation and the Swiss government for inviting me to represent the African Committee of Experts on the Rights and Welfare of the Child, the monitoring body for the African Charter on the Rights and Welfare of the Child, otherwise known as the African Children's Charter. In my 20 minutes, I'm going to give a very brief overview of the way in which the African Charter fits into the African Union system and the increasing linkages between our committee and different structures within the AU. I'm going to relate this wherever I can to the field of juvenile justice. I'm going to look at some of our recent activities insofar as they relate to juvenile justice and other aspects, and conclude with some recommendations and observations. So it's important to bear in mind that the African Children's Committee fits into a regional structure. We call it the African Human Rights Architecture, which consists, amongst other things, of the African Union Commission, headed by South African Nkosazana Dlamini-Zuma, which is the driving force behind the work of the African Union, and complemented by three independent organs: the African Commission on Human and People's Rights, the African Committee of Experts on the Rights and Welfare of the Child, and a more recent development in the form of the African Court on Human Rights based in Arusha. We regard the African Commission on Human and People's Rights, which monitors the African Charter on Human and People's Rights, which was inaugurated in the 1980s, and has been in existence now for many decades, as the mother treaty and the mother organ. And we regard ourselves as being, as it were, subsidiary to, in some respects, the mother treaty which gave birth to the African Charter. Many of the provisions of the African Charter which appear unusual, for instance, the provision on the responsibilities of the African child, is unusual only insofar as it is not prevalent or appears in other human rights treaties, but it appears in the African Charter on Human and People's Rights and is derived from that. With that as backdrop, at present the African Charter has 47 states parties who have ratified the Charter out of a possible 54 member states of the African Union. We're proposing for universal ratification of all member states of the African Union by the time of the 25th anniversary of the adoption of the African Charter, which will be in November this year. And you can read about our ratification campaign on the website of the African Committee on the Rights and Welfare of the Child. We know that we have new ratifications in progress. I was in South Sudan last year, and immediately following my visit, the new country of South Sudan ratified the Charter, and the ratification is on the way to be deposited in Addis Ababa. As far as reporting to the committee is concerned, as of the 1st of December 2014, 27 state party reports had been submitted. There are also some periodic reports that have been received from countries such as Kenya and Burkina Faso. And other state party reports have reportedly been received in the period since the 1st of December 2014 until now. So we are catching up with the consideration of state party reports to ensure that we do not go into backlog mode. Turning to the African regional system, it's important to note, I believe, that the African Commission has had a focus on deprivation of liberty for many years. A special rapporteur of the African Commission, otherwise known as the Banjul Commission, was established in 1996 to focus on deprivation of liberty. This is, of course, for adults as well. And the mandate of the special rapporteur on prisons has been renewed several times. There's been much activity in regard to deprivation of liberty, and I refer on the slide to the Robben Island Guidelines on measures for the prohibition and prevention of torture, cruel, inhuman, or degrading treatment or punishment in Africa of 2008, and the Ouagadougou Declaration and Plan of Action on Prison and Penal Reform in Africa of 2002. The African Commission on Human and People's Rights, the mother body, also adopted in 2003 principles and guidelines for the right to a fair trial and legal assistance in Africa, which of course covers all persons in the penal system, but there is a specific part, Part N, which deals very extensively with the position of children in penal systems. The principles and guidelines were also updated in 2011. So that brings me to the African Committee of Experts, which was established within 2 years of the Charter coming into force, came into force in 1999, and the committee has been operating since 2002, what is widely regarded as having been quite a slow start, due to a variety of factors: the lack of resources available to the committee, including research capacity, the lack of a secretariat, the lack of awareness about the committee by comparison specifically to the Geneva Committee, the CRC Committee, and significantly a need to develop rules and procedures for the various mandates of the committee, how to submit periodic reports, how to submit a communication, and so on and so forth. And the first chair of the committee, Kenyan Joyce Aluch, who is now a judge at the International Criminal Court, did significant work between 2002 and 2006 to develop the rules of procedure of the committee so that we could begin real work. There's been a significant output, I would argue, since about 2009, and I will allude to this on the next slide. It's important to note that in the same vein as our mother body, the African Commission, the African Committee of Experts enjoys a much broader mandate than the CRC Committee, and this is embedded in the provisions of the Charter. And I allude to some of these now. They are no particular order of significance, however. First, we have the capacity to grant organizations observer status, which gives them a heightened contact with the committee and the ability to sit in on special sessions which are otherwise closed. So far, we've granted observer status to more than 12 NGOs and INGOs working in Africa. And these include significantly some who have expertise and specialize in the juvenile justice field. I won't mention any names now for fear of leaving somebody out. But safe to say that we have very much contact with INGOs working in the juvenile justice sphere through our observer status process. Second, we have the ability, only just established under Optional Protocol 3 for the CRC Committee, we have had the ability to receive communications or otherwise individual complaints. To date, we have received 4 individual complaints, and there's a whole story behind why it's taken such a long time for us to receive and consider these communications. Some of which relate to the fact that we didn't have rules of procedure for the consideration of communications, and other reasons relate to the fact that governments, in respect of whom communications were received, challenged the veracity of the communications, and this required an evidence-finding process or a fact-finding process, which in one instance included a country visit to the applicable area to do on-the-ground research as to whether government or the complaint was justified. We have handed down decisions in 3 of the communications received, one against the government of Kenya, one against the government of Uganda, and the government of Senegal in the third communication, which is peripherally relevant to juvenile justice because it is a complaint against the government of Senegal concerning its inability to deal with the street children, the Talibé, children who are attached to the marabout and sent out on the streets to collect money and arms at the risk of their education, health, and in violation of child labor provisions. The fourth communication received is sub judice, so I cannot refer to it at all. We have yet to take a decision on its admissibility. The committee has commenced handing down general comments on provisions relevant to the Charter. The first general comment was on Article 30 of the Charter, a unique human rights provision which is peripherally relevant to juvenile justice. It deals with the children of imprisoned caregivers, and I'm pleased to announce that with the assistance of Penal Reform International, who are represented here today, there are copies of the general comment that are available downstairs at the PRI table. The second general comment deals with Article 6 of the CRC, of the African Charter, which concerns birth registration, nationality, and combating statelessness. And that general comment, which is available on our website, will be formally launched in the Ivory Coast in 2 weeks' time. We have a third general comment in preparation on Article 31, the responsibilities of the child, and 2 more are planned for the foreseeable future. One is on general measures of implementation of the Charter. The committee also has a mandate to commission studies, a mandate that we have not yet exercised until now, due principally to the lack of resources available for this. However, we have been tasked this year with developing a concept note for an African-wide study on children affected by armed conflict. That concept note has been approved and is being investigated by the African Union Heads of State Summit, which is taking place this week. The second study we have agreed to undertake is a study relating to children with albinism and violence against children with albinism, focusing particularly on Tanzania. The committee has a mandate to undertake investigative missions. There were investigative missions to Darfur and to northern Uganda in 2004. After that mission ceased due to the lack of funds and capacity, but they have resumed. In 2013, there was a mission to northern Uganda to investigate the communication against Uganda, as I mentioned. And in 2014, there were missions taken to South Sudan and in December to the Central African Republic to explore the impact of the current conflict on children. In 2014, actually not 2015, we were also requested to appoint a special rapporteur on early marriage and child marriage by the Department of Social Affairs of the African Union Commission to complement the work that they are doing on early marriage. To return to juvenile justice, I think the highlight of our engagement with juvenile justice was our participation in the Kampala Conference on Child Justice in Africa, the website of which is still available and the address is given there, at which juvenile justice was specifically in the spotlight. And a large number of organizations present here today were involved and present at that conference. At that conference, the endorsement was given for guidelines on action for children and justice systems in Africa, a document which paralleled to some extent the Council of Europe guidelines on child-friendly justice, but to a greater extent drew on the African Commission's work on fair trial rights that had been developed, as I mentioned earlier, in 2003 and updated in 2011. The idea being to look to the internal regional jurisprudence rather than look exclusively to European developments for the development of guidelines for Africa. So what is different, I suppose, to select a few things, is the focus on child soldiers, in the guidelines on action for children in the justice system, the focus on adoption and inter-country adoption, the focus on restorative justice and indigenous justice mechanisms, and so on and so forth, which may not appear to the same extent in comparable child-friendly justice guidelines. We've started to refer to the guidelines on action for children in the justice system in Africa in our recent concluding observations in providing guidance to state parties. In addition, throughout the various terms of the committee, there have always been members with direct experience of the juvenile justice system in their national jurisdictions. We've got judges, judge from Zimbabwe at the moment, heads of family courts from Senegal and from Nigeria, head of an organization providing legal aid to children from Tanzania, and so on and so forth. So there have been individual members with specific expertise nominated to sit on the committee for that reason. We have, each committee member is allocated a theme. Juvenile justice is, or children in conflict with the law is one such theme, and so we have a specific committee member who has ab initio responsibility for this sphere. So I come to my added comments and considerations. The highlight, as I mentioned, of our involvement with juvenile justice can be seen to be November 2011 with the Kampala conference. And since then, the committee has been more concerned with items that are priorities on the AU agenda, such as birth registration, children in armed conflict, and early marriage, illustrating the increasing synergy between the work of the committee and that of other organs of the AU. There are pre-trial detention campaigns underway in parts of the continent. These are not dedicated to children, but they can help provide impetus. And I refer specifically to the work of the Open Society Foundation in a large number of southern and eastern African countries focusing on pre-trial detention generally. There are a multiplicity of training initiatives, especially relating to the police, on juvenile justice, child-friendly justice, child victims, and so forth. Similar endeavors seem to pop up, and the work seems to get repeated in countries all over the continent. And so there's a question there about how to provide some, to synergize those efforts so as to save resources and to increase capacity. There is an ongoing rollout of specialized courts in many countries. Malawi, for instance, now has 28 specialized children's courts dealing with child victims as well as children in conflict. Kenya has specialized courts in every country, and many countries now have specialized police units for women and children to deal with victims particularly. I turn to some more controversial issues. In the mid-2000s, around 2006, the concept of J4C, Justice for Children, took root in donor agencies. There was a conference in Lilongwe in Malawi in 2009. And that doesn't seem to be very much prevalent anymore. J4C was an initiative to bring together, in the same vein as child-friendly justice, children in conflict, together with justice provided to children as victims and witnesses. But it didn't attract donor attention or support, and donor support seems to have moved very much in waves. We have also seen the development of a system strengthening approach, particularly in sub-Saharan Africa. There's quite a lot of documentation on this from, for instance, Save the Children. There are a large number of donors supporting the system strengthening approach to justice for children and to child protection. The committee received a presentation on this in 2014. But I believe that although there are huge merits, and I can discuss this in detail over tea, to a system strengthening approach which focuses from building child protection systems from the bottom up, training of the social workforce, developing child protection mechanisms at grassroots level, nobody could argue that these are not all very good things. The demerits of the system strengthening approach is that it detracts completely from juvenile justice reform. Juvenile justice reform is predicated on contact with the justice system. Different role players are involved. For instance, prison officials who are in charge of detention facilities, and they are not attracted at all by a system strengthening approach. So there has been a dilution of attention on juvenile justice. Law reform has been done in very many countries, most recently in Angola in 2013. It's usually compliant with the international instruments, with the CRC, with the African Charter, but it's really a question of implementation which needs human and financial resources and a more deeply embedded will amongst the role players. And I refer particularly here to the judiciary, who tend to get left out when one deals with a system strengthening approach. Diversion and restorative justice, I think the highlight of innovation was between 1990 and 2000 at country level. There was huge interest, many pilot programs, a lot of sharing between countries, but there's a sense that this has dissipated and that the energy has moved on. And this, of course, is also related to donor interest. Organizations that were involved in diversion services all of a sudden became counselors for HIV/AIDS patients because the funding was all related to health. So my conclusions are that the African Committee has the potential to foster and further juvenile justice reform in meaningful ways through many of the different mandates that we have. For instance, the mandate to undertake studies. We could do a study of juvenile justice or the deprivation of liberty across Africa. But this needs to be put on the table and furthered by the donor community and by NGOs in a much stronger way, because our attention has been, to use the pun, diverted to birth registration, early marriage, and children in armed conflict. Thank you.
Je remercie vivement Madame Sloot-Nielsen pour ces informations intéressantes. J'ai l'honneur de donner maintenant la parole au juge Andrew Beecroft, juge principal de la Cour des mineurs à Wellington, Nouvelle-Zélande, comme représentant de la Conférence régionale des tribunaux des mineurs du Pacifique Sud. S'il vous plaît, monsieur.
Thank you for your warm welcome. On Saturday, my wife and I visited the Patek Philippe Watch Museum, and one of the very impressive features of it was the mathematical provision of watchmaking. So I thought I would begin by asking you some mathematical quiz questions. What are the significance of these numbers? Addressing, as I am, the brightest and the best professionals in the world on youth justice, these are the answers. In New Zealand, 44 million sheep. 8,000 each year youth justice family group conferences, reserved for that small group that come to court. Our family group conferences are aimed at our most serious offenders. And since 1989, when family group conferences were mandatory for all young offenders, we have had 200,000 family group conferences in New Zealand. In one sense, the home, and we say that as a real privilege, of family group conferences. So I bring you greetings from Aotearoa in New Zealand, tēnā koutou katoa, in the second language, official language of New Zealand. But you know, I don't come today to talk about New Zealand. One of the things that most impressed us about the Patek Philippe Watch Museum was the perseverance and the vision of Monsieur Patek and Monsieur Philippe. They had a vision to create the best watches in the world. And surely that is what unites us. We desperately need a vision, a shared vision, to create and to implement the best youth justice system in the world. It was hugely inspiring and encouraging to hear Ms. Martins today speak of 2015 as being a pivotal year for youth justice. How I hope that is the case. So we share that vision. Indeed, in the Old Testament, the book of Jeremiah says in one verse, "Where there is no vision, the people perish." Where there is no dream for a youth justice system, we wither, we deteriorate, we atrophy. So what I want to talk to you today is about one small, modest example of regional cooperation where we try to share a vision for youth justice. We don't have, I'm probably the odd man out here, we don't have a South Pacific Charter, we don't have written instruments. We want to talk to you about a small and growing grassroots, bottom-up example of cooperation. Because no longer can we in youth justice operate individually as countries. We are not islands. This is a wonderful example of international cooperation, but we need first and foremost to build blocks by country and regionally. So when I talk about the South Pacific, perhaps a creative paradise, this is what I'm talking about. And many of you will know these countries. If you don't know, here's a brief geography lesson. If you're from Fiji or Tonga or Samoa, you would say this is the region that is paradise, the one paradise you don't have to die to go to. So how are we organised? Just very briefly, this is a, I guess, judicially led example of cooperation. I mean, judges aren't legislators, but we can use influence to develop cooperation and unity. And often in most of our countries, youth justice is marginalised, misunderstood and put to one side from the criminal justice system. We need to raise the profile of youth justice in our countries. We meet annually. We aim to encourage what we call Pacific-specific, United Nations compliant youth justice legislation, which for most countries in our region is just a dream, but we can talk about practices and development of care and protection practices and processes, because for most of us, those two systems are inseparable. The same people who appear in the youth court are already known to our care, abuse and neglect systems. In New Zealand, 80% of those appearing in the youth court come from a background where the state has already intervened in their lives. And the boys, and they're mainly boys in the youth court, and what unites us in the South Pacific and unites us all here is that we are dealing with the same young people. 85% boys from fractured and disadvantaged and alienated homes who appear in court with their mothers or their grandmothers, lost to the education system, often drug and alcohol dependent, facing severe psychological disorders, often fetal alcohol syndrome, learning disorders, and disproportionately Indigenous. And we partner with United Nations organisations, with the Commonwealth Secretariat. This is us meeting not like 800 people, but more like 40 or 50 in Apia in Samoa. What then are the challenges for us in the South Pacific? It is a vast surface area of the globe, 4 times at least the surface area of the USA. Kiribati has an economic zone bigger than the surface area of the US. We are on an isolated bottom left-hand corner of the world. But that gives us an advantage. We can be creative, we can try new ideas, we can innovate. We're a region of huge contrasts. Some countries, such as New Zealand and Australia, are enormously privileged. We have specialist youth courts, specialist judges. In New Zealand, a specialist police force of 300 young people for whom all young offenders who are apprehended have to go to. Specially trained, more highly paid. Specialist family group conference coordinators, social workers, youth workers, and about 300 in New Zealand state-funded, irrespective of means, lawyers, youth advocates. It's a highly specialised system and we are so grateful for it. But you contrast that with Kiribati, with no legislation, no specialist court, not even access to the internet. There are huge challenges. Nearly 50% of the region is 18 or under. Indigenous populations in Australia and New Zealand and Fiji and Samoa are disastrously overrepresented in the youth justice system. In New Zealand, 18% of our population is under 18 and Maori. 18% of the under 18 population are Maori. Of those in custody in New Zealand, 68% are Maori. that is a social catastrophe. It's as bad in Australia with the Aboriginal offenders. And youth justice in the South Pacific is a political football. There are enormous punitive swings of the pendulum, most recently in Queensland. So setting that scene, what are our priorities? Would that we could have specialist youth justice legislation in every country. That is our starting point, UN compliant legislation. But in the meantime, there are 4 things that we are prioritising. And I suggest they are 4 aims, 4 parts of our vision that apply to all of us. One is to increase rates of non-court charging and police alternative resolutions. That means training the police, developing a specialist youth police force who can deal with young offenders without bringing them to court. Much of what I've heard so far, talking about diversion and alternative resolution, starts with getting young people into court and then diverting them out. Our aim in the South Pacific region is to have 80% of young offenders not charged, not brought to court, but dealt with in the community with firm, prompt, community-based intervention, specialist police supervised. Because the last thing we want to do for most young offenders is bring them to court. Most young offenders, and we know this from the brain science, the world-leading US brain science says at age 14, the frontal lobe of the brain, that deals with wisdom, decision-making and common sense, undergoes a second growth and pruning stage that finishes for firstborn girls in the early 20s, and if you're a last-born boy, the bad news is much later than that. So most adolescent offending is teenage only, which offenders will grow out of without coming to court with good community-based interventions. And our aim should be, can I suggest, internationally, 80% of young offenders need not, should not, do not need to come to court, but can be dealt with in other alternative resolutions. The second thing we can do for that small group that comes to court, the really tough, challenging young offenders, is for judges, and we're all committed to this now in the South Pacific, where a charge is admitted or proved, to direct a family group conference to discuss how the wrong can be put right, how the damage can be repaired, and what measures can be put in place to stop the offending happening again. There is no better forum than resolving offending, than involving family, community, victim, to come back to the court with a plan and a long-term set of obligations that a young person works through. Nothing works better. And thirdly, to develop separate youth court hearings and times and training with judges where there is no legislation. We don't need to wait for the legislation. If it isn't there, we can develop UN compliant processes. And the final, 4th priority is to develop Indigenous, Aboriginal courts for the overwhelming number of offenders who are Indigenous. And you'll hear more about that today, but that involves taking the court to, in New Zealand, a marae, a Māori meeting place, setting up the court there, a judge sitting with Māori elders in the Māori language, with culturally specific and adapted processes. I believe that in the years to come, Indigenous courts and Indigenous processes within the overall youth justice framework will be one of the growing international movements in the world. And for all of us, how we deal with Indigenous offenders is a significant challenge. So, with those fourfold priorities, what have we achieved? Well, it's been slow and modest achievement. We have developed our own 15-point plan by which we can challenge each other. New Zealand is challenged. With all our advantages and privileges, we don't include 17-year-olds in our youth justice system. And what a tragedy that is. Or does Queensland. With all our advantages, we are in flat-out, flagrant, direct breach of the United Nations Convention. There's been some developments for youth justice legislation. There are significant training programs. We have good mentoring arrangements, country to country. We put a lot of effort in. Usually it means Australia and New Zealand pays with all our resources. And in New Zealand we have rangatahi courts where Māori are dealt with on the marae, Pasifika courts where Pacific-based people are dealt with in community, Pacific Island meeting houses. In Australia they're the Koori court. Those ideas are taking on. That's the Pasifika Court in South Auckland in New Zealand, the largest Polynesian city in the world, which meets one day a week. You can see the judge, the right, flanked by Pacific Island elders, the traditional Pacific Island mat, the family there, maybe half an hour to an hour, working through a culturally appropriate approach. So in conclusion, I hope that has been a small window as to what is happening in one small, isolated part of the world, where we're forced to be creative. Although it's a paradox, youth justice needs to come of age. 2015 could be a big year for all of us. The question is, are we prepared to take the step? We need to work regionally. We need to hold each other to account. As part of our tour of Geneva, we visited, my wife and I, and Judge Cordero and his wife, the Alpine gondola at Salève, the cable car. It's just about vertical, 1,500 feet. When I got there, 3 of us got in the cable car, but I didn't. I looked right up and it was just too high for me. The door opened and I didn't hop in. Well, the door's opening for us in youth justice. I guess the question is, are we going to jump on board regionally and internationally with all the costs of challenge and learning that involves? I hope we can do it. Thank you.
Merci à Monsieur le juge pour cet exposé enrichissant. J'ai maintenant le grand plaisir d'accueillir Madame Regina Jens-Dottir, coordinatrice de la division des droits de l'enfant, qui va nous parler des travaux accomplis et en cours au sein du Conseil d'Europe dans le domaine de la justice juvénile. S'il vous plaît.
Good morning, everyone. It is a real pleasure for me to take part in this Congress, which we've been waiting for quite some time now. I'm delighted to be able to be here to share with you the vision of the Council of Europe and to share with you how we, in our 47 member states, how we are striving to make children's rights and children real right holders, and how we are striving to make sure that children are not treated as criminals, that they are not criminalized. I'm going to give you an overview of the way in which we work in my organization. and I'm going to give you examples of how we are working together with our governments to make sure that they are respecting the UN Convention on the Rights of the Child as well as the Council of Europe standards. I woke up in a nice bed with my family and I went to sleep with criminals. Is it really normal that children have such profoundly terrifying experiences before they enter into adulthood? Are we really allowed to rob them of their childhood, deprive them of family, deprive them of friends, education, support, deprive them of integration? They should have access to justice. They should have access to rights. They should have access to their human rights. They need more support, not more deprivation. For those who are not familiar with the Council of Europe, it is an organization which was founded in 1949 to protect human rights, the rule of law, and democracy. The Council of Europe promotes human rights through direct dialogue, exchange of ideas and problems between parliamentarians, between our national governments of the member states, and with civil society. And our role is really to serve as a catalyst for the implementation of the CRC. I think this is very important for me to convey here today. We do not have a regional committee which is protecting children's rights, but we see our role in the Council of Europe as being the regional hub for implementing the recommendations of the UN study on violence against children and, of course, of the UN standards which protect children. Today, I'm going to open up a little bit of a toolbox that we use in the Council of Europe. Our magical tools for making progress, for keeping governments on their toes, for supporting them to make this difference for every single child that is in conflict with the law. These are also tools which allow civil society organizations and the legislators in our member states to change laws and to change mentalities. We do it with these 5 tools. We have legal standards which are adopted by the member states together. We have mechanisms to monitor the implementation of those legal standards. We also have policy documents that are non-binding documents, but which have proven the power to change national policies and practices. We have also programs which help to support governments in changing legislations, cooperation or assistance programs. And we have awareness raising, and we launch initiatives and campaigns to help governments, civil societies, to understand better children's rights and how children should be treated and how their rights should be respected. In the Council of Europe, in order for us to be able to, or to have been able to focus strategically on children's rights, it was decided back in 2005 really to have a strategic focus. And we have now, over the past years, or since 2005, gone through different strategies. So in order for us to all work together, the different parts of the organization, we have a strategy, which we are now in the strategy of 2012 to 2015. And the program, Building a Europe Formed with Children, manages the implementation of this strategy. And one of the core strategic objectives are, of course, to fight violence against children through integrated strategies, and, of course, to promote child-friendly justice, child-friendly health and social services, and protect children in vulnerable settings. And in this area, we really focus on supporting juvenile justice system and children that are in detention and are deprived of liberty. And, of course, child participation is one of our key strategic objectives. So my job in the Council of Europe is to work with everyone who I think, and who the Committee of Ministers thinks, should look more closely and implement better the rights of children. But let me introduce to you, for those of you who do not know, of course our key convention in the Council of Europe is the European Convention of Human Rights. The European Convention is our guiding light, and which of all of our work is built. The Court of Human Rights, which observes the Convention's implementation, is often faced with cases that deal with children who have come into contact with the justice system, and they are doing so increasingly. Its judgments are binding on the countries in our member states. Its rulings are therefore have a great impact on the 800 million Europeans which live in the 47 member states of the Council of Europe. So the Convention and the Court actually functions as our watchdog of human rights, to make sure that the rights are respected. And although the Convention does not contain any explicit mention of children in its text, the rights contained therein apply, of course, to children as well. The Court has developed a lot of case law which confirms and reinforces the importance of respect for the specific situation of children. In regard to juvenile justice, the courts are required to have regard to the child's age, level of maturity, and the intellectual and emotional capacities of the child. And this includes the requirement that a court must always promote the child's ability to participate in the proceeding. And this is one of the challenges that we are facing in the Council of Europe member states, is how can we make sure that children participate in judicial proceedings, be they civil, administrative, or criminal proceedings. The fact that the applicant in a case before the court is a minor influences the court heavily in its application of the Convention rights, and the standards of protections required are increased considerably when a minor is involved. And this is especially true in respect of in detention. The standards for demonstrating the need for detention in accordance with Article 5 in the European Convention of Human Rights are higher than when adults are concerned. The Court has confirmed that pre-trial detention of minors should only be used as a measure of last resort and be as short as possible. However, when detention is strictly necessary, minors should always be kept apart from adults. The Court has particular regard to the vulnerability of children when determining whether treatment qualifies as inhumane or degrading treatment. And these standards, which are anchored in the Convention and the case law of the Court, serves as a basic protection of children's rights in Europe. These rights must always be protected, but we can, of course, go even further in our protection of juveniles in the justice system, and that is exactly what the Council of Europe does. We never take the thumb off the pulse. In order to support better the implementation of the UNCRC and the European Convention of Human Rights, we have developed guidelines on child-friendly justice, which were referred to earlier. The guidelines are today considered as one of the key references on how European Council of Europe justice systems can better respect the child as a right holder and how to ensure the child's access to the justice system, both civil, administrative, and criminal. They contain far-reaching provisions and apply in all circumstances when a child can come into contact with the justice system. And examples of integral principles: detention must, of course, always be a measure of last resort. Minimum age of criminal responsibility must not be too low. Professionals working with children in the justice system must receive training. And these principles were, at the time when we were drafting them, it was very difficult to negotiate some of these provisions into the guidelines. And then, unfortunately, there seems to be a widespread belief amongst politicians and officials that there is a need to get tough on crime. And even if that means to neglect the obligations that states have to protect their youngest citizens, this we cannot allow to happen. In the area of child-friendly justice, we have been working very closely with the European Union, which is another European organization of 27 member states. We have had very positive cooperation in the area of justice together with the European Commission and with the Fundamental Rights Agency, the FRA. We took the guidelines on child-friendly justice, and the Commission, the European Commission, commissioned a study where the guidelines were used as a template. And the outcome of the research, which was, and the data that was actually collected by both the European Commission and the FRA, revealed that there are serious gaps in implementation of these guidelines. There's a lack of training. There are different systems which are being put in place in the justice system in our member states. Sometimes the interviews are being conducted by social workers which have not been specifically trained. So these studies have revealed that there is a need for the European Union and the Council of Europe really to step up its efforts in making sure that the justice system is also accessible in a child-friendly or child-adapted manner to children. We have another important guidelines or rules in the Council of Europe member states. We call them the European Rules for Juvenile Offenders subject to sanctions or measures, which were adopted by the Committee of Ministers in 2008. The rules apply to all juveniles who are deprived of liberty, irrespective of in which setting the detention takes place. A broad definition of deprivation of liberty therefore applies. A special feature of the rules is that they regulate in detail the conditions which must apply when juveniles are kept in detention. They contain several basic principles that should serve as guidance for the member states. Of course, the best interest of the child. Any decision to impose or implement a sanction must be based on the best interest of the child or of the juvenile offender. Encourage states to promote mediation and restorative justice, as was pointed out by Marta Santos Pais and colleagues from UNICEF and UNODC earlier. And similar to the guidelines on child-friendly justice, the rules also require the age of criminal responsibility not to be too low. But it is interesting to note also that the study of the European Commission revealed that this age varies, and I think this is one of the ambiguity of our systems, is that we do not there are different systems in place, and I think that there's room for us to make progress in that particular area as well. Standard setting and monitoring. Deprivation of liberty is a punishment which often seems to be at the center of the national justice system, also in respect of children. And this is evident because when we talk about children's rights in the justice system, we talk about alternatives to detention and not detention as an alternative of last resort, as opposed to other measures. Both the guidelines and the European rules set by the Council of Europe have the same approach. It should always be the measure of last resort. But for me, this is not good enough. Children are exposed to violence, punishment, discrimination, exclusion. They are deprived of education and they need support. And as we stand today, there is still some way to go, but that is also why we're here today. How can we make progress quicker, and how can we make progress really work? Research has shown that children who have been in the detention system are much more likely to end up back in the detention as adults than juveniles who were subject to other restorative measures. What has also come, which is also an area where the Council of Europe is also working very hard with the member states, is to support them in training of professionals. The committee which drafted the guidelines on child-friendly justice, which has an abbreviation which we call the CDCJ, they provide legal advice, they organize regional activities to help the member states to really focus on the justice system, and they organize awareness-raising trainings. This committee has, in the past, in 2014, really stepped up its cooperation focus and is really now organizing conferences with other sub-regional organizations, such as the Council of Baltic Sea States, in order to raise awareness of professionals working in the justice system. So we are organizing regional seminars and regional events in order to help the professionals that have to use the guidelines in their daily life, be they social service or judicial service professionals, to really make the difference. The Help Network is also a network of the Council of Europe, which designs online training courses. So we are trying to make accessible everything that we have in an online form as well, so that the professionals that need to use the guidelines in their daily practice, that they can really benefit from it. I mentioned earlier that we have monitoring systems. Of course, we have another committee which is evaluating data of how the justice system is working. This is the Council of Europe Commission for the Efficiency of Justice System, which collects data. Because of the Council of Europe strategies and the mainstreaming approach that we have in trying to make other committees of the Council of Europe work on children's rights, CEPEJ has now started to look at the situation of children, which we think is very good. It means that in their general work they look at data on how children are being treated in the justice system as well. We also have the Council for the Penological Cooperation, the PCCP, which has drafted a number of recommendations on juvenile justice, and including the European rules for juvenile offenders, subject to sanctions and measures. The committee has just recently, at the end of 2014, adopted a report and submitted it to the steering committee on criminal cooperation, a report on violence in institutions for juvenile offenders. A report which responds partly to concerns of Marta Santos Pais in one of her recommendations. This report revealed that violence by staff against juveniles is a problem in many of the Council of Europe member states. Issues such as abuse of power, excessive use of force and solitary confinement are far too common. Corporal punishment is still an issue in some of our member states. And these are problems which we need to target head-on, and we need to apply strict criteria to the selection of our staff, and we need to train them well. And the Council offers such training programs, and I would like to encourage the representatives of our member states to take advantage of them. We are also working with the Committee for the Prevention of Torture, the Council of Europe Committee for the Prevention of Torture. Since 2010, we have really stepped up our cooperation with them, and this committee, which has its main function is to visit detention centers in member states of adults to assess the treatment of detained persons. This committee has unlimited access to detention centers, and after each visit they prepare reports and deliver recommendations to the member states. And now they are increasingly and more strategically looking at the situation of children in detention centers. We started off, in order to get this committee to help them along. The Children's Programme of the Council of Europe prepared a report together with an expert, which really looked at the way in which the CPT was looking at children in detention. And in this report, which was then submitted to the CPT, the CPT decided to revise its rules on visiting centres where, and sort of to review the way in which they look at detention centres where juveniles are detained, and how they can better support the states in improving their practice. And this committee, the CPT, issued only last week this report, which confirmed that in many member states children are still being detained with adults. In this report, they have expressed concern about the extent to which detention is being used. It is not being used as a measure of last resort in many of the Council of Europe member states. Juveniles continue to be held in police stations for 10 days or more. And in several member states, they are still subject to disciplinary measures such as solitary confinement. I'm not going to go through all of the references in the report. It is a highly interesting report which is being made available to the participants of the Congress. We also, of course, have the Council of Europe Commissioner for Human Rights. The current Commissioner has identified many shortcomings affecting juvenile justice in Europe: lack of access, lack of child-friendly procedures, and lack of non-judicial remedies. He's also expressed concern in relation to the widespread resistance to juvenile justice in Europe. And this is a reality in Council of Europe member states. Juvenile justice is still either perceived as undue state interference with parents' rights to educate their children or as an unduly weak response to youth crime. This may also be because of the prevalent view that protection of children's rights is seen as a matter of goodwill rather than the implementation of a state obligation. Why is the protection of children's rights not an equal obligation to the protection of human rights in general? I mean, this is something we still have to make progress in. Austerity measures. The Commissioner has worked quite a lot on looking at the situation of human rights in times of austerity. And his view is that austerity measures have had a big impact on juvenile justice. Prevention and integration programs have been heavily impacted by budgetary restrictions. Important complaint mechanisms such as ombudspersons for children's rights have suffered grave budgetary cuts in states. This has a deep negative impact on children's access to justice, and the Commissioner has urged states to use the background of the crisis as an opportunity to review their policies and make them both more cost-effective and more respectful of children's rights. We cannot let austerity measures undermine the fundamental rights of children. States have to adapt to a new, different economic era and to find new ways to protect the rights contained in the obligations that they have undertaken. A lack of budget is never a reason to give discount on rights. The Parliamentary Assembly of the Council of Europe is also an important organ body of the Council of Europe. I'm running out of time, so I'm not going to go into the work of the Assembly, but they are very crucial to our work because parliamentarians meet in Strasbourg and they debate issues where they consider there's a need for a debate between countries. And most recently, they adopted texts which they've been looking in 2014 at the situation of justice in Europe, of juvenile justice. And they have adopted a report and a resolution on child-friendly juvenile justice. So we have parliamentarians among our supporters in making sure that justice is more friendly to children. And of course, we work very closely with civil society in all of our endeavors. I think that there are new challenges which are up ahead. I think that in the Council of Europe we have a lot of migrants, we have a lot of children that are Roma, children that are in vulnerable situations which are criminalized too easily. I am concerned about our failure of integration of migrants and the impact that this is having on criminalization of that particular group of children. And I think this is something that the Council of Europe is going to have to look at very quickly in the light of the circumstances. As a concluding remark, I think that none of us have a magic wand to make all of these different tools work together. But I think that together we can make this magic wand. We have the power to change, we have the power to intervene, we have the power to persist, to stand up for the rights of children and to work hand in hand. All in our separate ways, through our separate channels. So I want us to think right now of all the children that are sitting on their own behind locked doors, chained to their mistake, to the education and support they did not get, to the children and the boys and girls that are sitting and wondering if there is anyone out there with a magic wand. Thank you.
Merci beaucoup, Madame Jens-Dottir, pour cet exposé très intéressant. J'ai le plaisir de donner la parole à Monsieur Fernando Ferrero, secrétaire général de la coordination des ministres de la justice ibéro-américain Costa Rica, qui va nous présenter la situation dans la région ibéro-américaine. S'il vous plaît, Monsieur Ferrero.
Muchas gracias. Buenos días a todos, señoras y señores. Yo agradezco profundamente al gobierno de Suiza y a la organización Tierra de Hombres la oportunidad que me dan de participar en este congreso y de referirme a la Declaración Iberoamericana sobre Justicia Juvenil Restaurativa. Hay 3 temas que, aunque brevemente, me interesa de manera especial compartir con ustedes. Los 3 temas se resumen en 3 preguntas. La primera es, ¿qué es la Conferencia de Ministros de Justicia de los países de Iberoamérica? La segunda, ¿cuál es la relación o cuál ha sido la relación entre COMGIP y Tierra de Hombres? Y finalmente, ¿cuáles han sido los resultados de esa relación en el tema que nos ocupa, es decir, el impacto de la Administración de Justicia en el desarrollo desde la perspectiva de la juventud? Y aquí me adelanto y les digo que el resultado es precisamente esa declaración iberoamericana de las que les hablé antes. Me disculpo porque no traje conmigo apoyo audiovisual. La Conferencia de Ministros de Justicia de los países de Iberoamérica es una organización internacional creada en el año de 1992 mediante el denominado Tratado de Madrid. De la organización forman parte todos los ministerios de justicia e instituciones homólogas de España, Portugal y de los países latinoamericanos, desde Argentina y Chile hasta México. Su órgano ejecutivo es la Secretaría General, la cual tiene su sede en Madrid. La organización persigue como objetivo fundamental el de apoyar a los países miembros en sus esfuerzos por mejorar la justicia en el espacio iberoamericano. Promueve la creación de políticas públicas de ámbito nacional y regional aplicables por los Estados miembros, así como el establecimiento de alianzas destinadas a la construcción de un espacio jurídico más cohesionado. Aquí es importante aclarar, cuando me refería a instituciones homólogas de los ministerios de justicia, el hecho de que muchos de nuestros miembros actúan a través de los ministerios de gobernación y de interior, y en el caso de algunos de los países directamente a través de su Corte Suprema de Justicia o de las Procuradurías Generales, como es el caso, por ejemplo, de México y de República Dominicana. Yo diría que el elemento central que define a esta organización es precisamente la cultura jurídica común. No solamente compartimos 2 idiomas, como sucede con el portugués y el español, sino que también los países miembros de COMGIP comparten una forma común de entender el derecho y la administración de justicia. Eso facilita ampliamente el trabajo que en cada uno de los campos que describiré más adelante realiza la organización junto con sus miembros. El segundo elemento que caracteriza esta organización es la cooperación sur-sur, como instrumento de trabajo esencial. Este constituye, como les decía, la otra gran seña de identidad de COMGIP a través del intercambio de experiencias y de la transferencia de conocimientos y tecnología. Para lograr sus objetivos, la COMGIP utiliza diferentes instrumentos, entre los cuales se destacan los siguientes. Primero hablaría de la creación de acuerdos jurídicos interministeriales que establecen marcos comunes de actuación para la región, incluidos entre otros instrumentos internacionales y recomendaciones, y además se aprueban estándares de calidad y compromisos de cumplimiento por parte de los ministerios. La puesta en marcha de programas de cooperación al desarrollo a partir de los resultados logrados por los grupos de trabajo es otro de esos instrumentos. En estos programas, algunos países actúan como transferentes de buenas prácticas y otros como receptores, según los esquemas de la cooperación sur-sur y de la cooperación triangular. Actualmente la COMGIP desarrolla 5 áreas de trabajo de acuerdo al mandato recibido durante su última asamblea plenaria realizada en Viña del Mar, Chile, en abril del año 2013. Esos 5 campos son los siguientes: acceso a la justicia, donde trabajamos en la sistematización y promoción de políticas públicas para mejorar precisamente el acceso a la justicia en el marco de planes integrales de acceso o focalizados en líneas como la mediación juvenil y la asistencia a víctimas de la violencia de género. La modernización de la justicia y las nuevas tecnologías. En este campo, la promoción de políticas de innovación tecnológica en el sector justicia, como el uso de la videoconferencia en los tribunales, cero papel y el portal iberoamericano de justicia electrónica. Reforma de los sistemas penitenciarios. Se impulsan mejoras a través de la integración del enfoque de derechos humanos en el tratamiento de la población reclusa, especialmente de las mujeres madres, así como la promoción de medidas alternativas a la prisión. Es especialmente relevante la aprobación y actual implementación de una guía de infraestructura penitenciaria que reconoce la relación entre entre el diseño de las instalaciones y el respeto y promoción de los derechos humanos en el medio carcelario. La promoción de políticas coordinadas de combate a la delincuencia organizada, la promoción de instrumentos jurídicos de ámbito iberoamericano y la armonización de tipos penales, así como la creación de equipos conjuntos de investigación, forman parte de la línea de trabajo en el campo del crimen organizado. La siguiente área es la prevención del delito. Promoción de una visión integral de la lucha contra la violencia y el delito con el fin de aportar un enfoque de políticas alternativo y complementario a los enfoques represivos y de control en las políticas preventivas. En este último tema se han desarrollado proyectos particularmente importantes como el que tenemos en marcha con el Sistema de Integración Centroamericana en el marco de la Estrategia de Seguridad de la región, que junto con la COMGIP ha desarrollado 2 textos normativos de trascendencia, como es la Orden de Detención Centroamericana, que emula la Orden de Detención Europea y pretende ser una alternativa a los engorrosos procedimientos de extradición, así como el Proyecto de Cooperación Jurídica Reforzada en Centroamérica. Este proyecto está siendo apoyado en estos momentos por la Comisión a través de su programa de apoyo a la Estrategia de Seguridad de Centroamérica, de cuyo portafolio de proyectos forma parte. Asimismo, la CONGIP, por mandato de su última asamblea plenaria, ha trabajado en el texto de un convenio iberoamericano sobre aseguramiento y obtención de prueba en materia de ciberdelincuencia, así como una serie de recomendaciones para la modificación de la normativa nacional de los países miembros. Ambos textos en este momento se encuentran en manos de los Estados para darles el trámite correspondiente. Otra línea de acción en la que hemos dado los primeros pasos es la lucha contra la minería ilegal y contra el tráfico de bienes culturales. Dos formas distintas de la criminalidad organizada que impactan en la región latinoamericana y que está teniendo impacto en diferentes aspectos, como el medioambiental, la trata o el trabajo infantil. También en la última plenaria se acordó trabajar en el tráfico ilícito de bienes culturales como otra de las formas de criminalidad organizada con impacto especialmente en el blanqueo de capitales. De la Conferencia Iberoamericana forma parte también la Red Iberoamericana de Cooperación Jurídica Internacional, que reúne a las fiscalías generales, a los ministerios públicos de sus países miembros y a las Cortes Supremas de Justicia de cada uno de los estados que forman parte de ella. Me refiero a la Asociación Iberoamericana de Ministerios Públicos y a la Cumbre Iberoamericana de Cortes Supremas de Justicia. Disculpen que haya hecho esta descripción tan detallada del trabajo de los campos donde COMGIP opera y que no tienen que ver directamente con el campo que nos ocupa el día de hoy, pero quería con esto describir esa plataforma tan amplia y efectiva que reúne a 21 estados en temas, trabajando en temas relacionados directamente con la justicia y parcialmente con temas de seguridad, porque precisamente en este campo es donde el tema que nos ocupa, el de la justicia juvenil, resulta de mayor importancia, el aporte que como organización podemos hacer, y aquí es donde la relación con Tierra de Hombres cobra una importancia significativa. Nosotros tenemos claro que incluso trabajando desde el espacio iberoamericano, tenemos claro que no hay un solo problema de naturaleza pública que pueda entenderse o tratarse en términos estrictamente nacionales. Y al mismo tiempo, los diferentes organismos internacionales, con independencia de su naturaleza, todos debemos entender que nos complementamos, que tenemos debilidades y fortalezas que nos permiten, si trabajamos juntos, tener una muchísima mayor efectividad. Y aquí es donde entra entonces el trabajo que hemos realizado con la organización Tierra de Hombres. Desde finales del año 2013, gracias a conversaciones que tuvimos con el señor Víctor Herrero, iniciamos un proceso entre la CONGIP y Tierra de Hombres para trabajar de forma conjunta en materia de justicia juvenil. La organización Tierra de Hombres, su experiencia y reputación en el ámbito iberoamericano son elementos claves que nos permiten trabajar de manera conjunta para conseguir el apoyo a la mejora y fortalecimiento institucional del sector justicia, así como mejorar la calidad del servicio judicial del que son destinatarios millones de jóvenes en nuestros estados. La justicia juvenil es hoy una de las principales preocupaciones al abordar la relación entre justicia y desarrollo humano, tanto por razones cualitativas, y aquí me refiero a la percepción subjetiva de inseguridad y al papel de los menores en la delincuencia, como a razones cuantitativas, especialmente a lo que denominamos el bono demográfico de la región. El 9 de enero del año 2014, el señor Philip Bush, en representación de Tierra de Hombres, y quien les habla, como secretario general de la CONGIP, firmamos un convenio de colaboración entre ambas instituciones basado precisamente en las preocupaciones señaladas. Como no puede ser de otra forma, ambas organizaciones reconocemos el interés en la promoción de los derechos de los adolescentes y jóvenes involucrados en fenómenos de violencia y que son afectados por las instituciones del sistema de justicia de los distintos países de Iberoamérica. De igual forma, nos interesa profundizar en todo lo relacionado con la modernización del sector de la justicia juvenil, así como el acceso de los adolescentes y sus familias a la misma. El primer trabajo conjunto que realizamos fue la elaboración de un primer borrador de una declaración iberoamericana sobre justicia juvenil restaurativa. Los días 23 y 24 de abril del año 2014 se realizó en la ciudad de Cartagena, en Colombia, el primer encuentro iberoamericano de justicia juvenil restaurativa, con el objetivo de reflexionar sobre este tema en el espacio iberoamericano, intercambiar experiencias, lecciones aprendidas, buenas prácticas y elaboración de los contenidos básicos del borrador de la declaración mencionada. Los frutos de este encuentro fueron presentados el día 6 de noviembre en Madrid ante diversos expertos, así como ante el cuerpo diplomático. Posteriormente, también en Cartagena de Indias, a finales del mes de noviembre, se realizó el segundo encuentro iberoamericano de justicia juvenil restaurativa, que validó el documento dicho. Los resultados de la declaración. El trabajo que conjuntamente realizamos Tierra de Hombre y CONGIP dio como resultado el texto del proyecto mencionado. Me permito destacar que ambas organizaciones aspiramos a que éstas sirvan como insumo para los diversos países de la región, para que adopten las medidas pertinentes en la materia. Las principales recomendaciones. La primera, los Estados iberoamericanos, a través de sus autoridades competentes, tomarán las medidas necesarias para la revisión y la reforma de la legislación interna pertinente, a fin de asegurar que la aplicación de las sanciones de privación de libertad contra personas obedezca a los principios de flexibilidad y excepcionalidad. La segunda, los Estados iberoamericanos, en el momento de tomar una decisión respecto a los adolescentes que han infringido la ley penal, tendrán en cuenta su derecho a la protección integral, su bienestar, el carácter socioeducativo de las medidas a adoptar, así como cuidar para que los adolescentes sean separados de acuerdo con su edad, complexión física y gravedad del delito, y la necesidad de reparar el daño a la víctima y a la comunidad, priorizando la desjudicialización, así como las medidas alternativas a la privación de la libertad, especialmente la prestación de servicios a la comunidad. La tercera recomendación: los Estados iberoamericanos deberán tomar todas las medidas necesarias para que sus autoridades competentes puedan valorar los impactos de las sanciones privativas y no privativas de libertad mediante informes biopsicosociales o de otra índole antes, durante y después de aplicarlos a cualquier niño, niña o adolescente en conflicto con la ley penal. La cuarta, los Estados iberoamericanos, a través de sus autoridades competentes, deberán velar por la revisión periódica de la medida o sanción de privación de libertad y de las medidas o sanciones alternativas de la privación de libertad. La quinta, los Estados iberoamericanos deberán implementar sistemas de control, seguimiento y monitoreo eficaces y respetuosos de los derechos humanos de los niños, las niñas y los adolescentes, respecto de las medidas o sanciones privativas y no privativas de libertad, así como las competencias de las instituciones encargadas del seguimiento y control de dichas medidas o sanciones, a través de un trabajo intersectorial que involucre al sector público, a la empresa privada y a la sociedad civil. Los Estados iberoamericanos deben procurar que la reincidencia no sea considerada una condición que impida la aplicación de medidas alternativas a la privación de libertad. Esta sería la sexta recomendación. La séptima, los Estados iberoamericanos deben promover la implementación de sistemas de información confiables, automatizados, disponibles en línea, integrados con la información de todas las instituciones involucradas, con niveles de seguridad para el acceso, edición y confidencialidad de la información. Los Estados deben considerar, además, la creación de un grupo de trabajo iberoamericano para la estructuración de nuevos indicadores cualitativos y cuantitativos que permitan valorar la eficiencia y que el cumplimiento de los sistemas de justicia juvenil, que a la vez midan las necesidades de las instituciones a la hora de planificar los recursos y políticas públicas. Esta sería la octava recomendación. En este mismo campo, los indicadores mencionados deberán estructurarse con perspectiva diferencial de etnia, de género, que garantice la igualdad en el acceso a la justicia de los y las adolescentes. La novena recomendación: los estados deberán considerar la posibilidad de investigar sobre la aplicación de la justicia originaria de cada pueblo indígena, afrodescendiente u otro en su territorio y sistematizar la información obtenida con el fin de identificar buenas y malas prácticas de justicia originaria con potencial restaurativo y fomentar su difusión. La décima: los estados deben fomentar estrategias de formación y capacitación de justicia juvenil con participación de la comunidad, instituciones del Estado, empresa privada, con el fin de consolidar lenguajes comunes y autorizar conceptos a partir de modelos pedagógicos vivenciales y participativos, promoviendo siempre que sea posible intercambios con experiencias de otros países iberoamericanos, apuntando a una aproximación conceptual y del lenguaje acerca de la justicia juvenil con enfoque restaurativo en América Latina. Como pueden ver, el objeto de esta declaración es no solo buscar el consenso en unos mínimos comunes entre todos los operadores del sector justicia, sean ministerios, poderes judiciales, fiscalías, defensorías, abogacías del Estado, sino ser un auténtico motor de impulso transformador en las políticas locales. En cada una de las normas y de los protocolos de cooperación interinstitucional, inspirar los modelos de gestión y las estrategias de intervención de nuestros gobiernos para mejorar la calidad de un servicio público que afecta a nuestra libertad y a nuestra seguridad. Confiamos en que este proyecto de declaración iberoamericana pueda servir como un valioso insumo que pueda ser replicado en otras regiones. COMHIP tiene su asamblea plenaria en mayo de este año, se realizará en la República Dominicana y allá el proyecto de declaración será sometido a conocimiento de los ministerios de justicia e instituciones homólogas de los estados, de todos los estados miembros de la organización. Muchísimas gracias.
Merci beaucoup à tous ces intervenants pour leur présentation très instructive sur les différentes approches régionales de la justice juvénile. Nous allons terminer cette première matinée de congrès par une table ronde sur la diversité des fondements juridiques à l'intérieur d'un pays face aux normes internationales. Pour modérer cette table ronde, nous avons la chance de pouvoir faire appel à Madame Marie Wernham de Grande-Bretagne, qui est consultante internationale en droit de l'enfant. Elle discutera avec Monsieur Roy, Monsieur Ali, Monsieur Al-Soulov et Monsieur Tomanou. Je vous prie de vous installer en devant de vous préparer pour cette table ronde. Merci beaucoup.
Welcome. Thanks not only to our lovely hosts, but the great work of the interpreters and the volunteers everywhere. I am joined with a very distinguished panel of guests. I will introduce them, and then we will have a form of discussion to address some key questions. So starting from your left, we have Judge Hemi Tomonu from New Zealand. He is the National Rangatahi Courts Liaison Judge in New Zealand. We just heard briefly from Judge Beecroft about that Rangatahi court system, which aims to reduce reoffending by Maori, that's Indigenous youth, and to provide the best possible restorative and rehabilitative processes involving families and communities. He presided over the first of these courts in 2008, and since that time 11 other Rangatahi courts have been launched around the country. We will hear more about that shortly. And then on my immediate right we have Mr. George Abu Al-Zulof from Palestine, from the Office of the High Commissioner for Human Rights. He is currently head of the office in Yemen. He's a child rights expert with over 20 years' experience in human rights and humanitarian law, including 10 years as head of the Palestine section for the NGO Defence for Children International, and also 5 years as justice specialist for UNICEF in Yemen, working also in Libya, Iraq and Lebanon. On my left, we have the Honourable Justice Muhammad Ali Iman Ali, who is currently a judge of the Appellate Division Supreme Court of Bangladesh. He has practiced law in both the UK and Bangladesh, and he's been involved in the training of police, judges, prosecutors and government officials in Bangladesh and Armenia on juvenile justice issues and victim survivors of trafficking. In December 2014, he was awarded the Juvenile Justice Without Borders International Award. Congratulations. From the International Juvenile Justice Observatory. And then finally, on my far left, is Mr. Nikhil Roy. He's currently Programme Development Director at the NGO Penal Reform International, based in London, working on criminal justice reform worldwide. He's the author of several contributions on child detention and various toolkits, and has extensive experience in human rights issues, including access to justice, alternatives to imprisonment and juvenile justice. He's worked on projects in these areas around the world. So, wise and wonderful people, all of them. To respect time, we will save all applause until the end, please, and I'm sure there will be much of it. So, our topic for this discussion: is it really possible to implement universal international norms in countries with such diverse legal, judicial, cultural, religious and governmental traditions? If it is possible, how? What are the lessons learned, success stories, challenges and ways to overcome these challenges? Now, we could take two opposite ends of the spectrum for approaches and mindsets towards this issue. The first is mindset number one, very top-down, that international norms are this alien concept devised by others somewhere at some vague international level. They need to be enforced on unwilling stakeholders, for example, through trainings which say this is how it should be done. Now go away and do it. So this is one extreme, and I'm not saying that people here are of that mindset, but it's one end of a spectrum. The other end of the spectrum is more bottom-up. So the international norms are largely derived from human rights, which are themselves drawn from universal human experience on the ground. Issues such as justice, compassion, responsibility, dignity, and so on. So these norms are not alien in and of themselves, but maybe we need to do a better job connecting and reconnecting them more clearly with the links to local cultural values. Now, this issue of connection and reconnection is one which I think you will find is a common denominator across our speakers' experience here. The need to move forward with stakeholders at the local level, bringing together the international norms with these common values, addressing the level of the head, knowledge, addressing misinformation, giving correct information in a way that is accessible and understandable. At the level of the heart, very importantly, sensitizing, addressing attitudinal change, and then moving to the level of the hands, helping with human and financial resources to actually implement things in practice. So maybe this is idealistic, simplistic. Maybe it does not take account of people who are gatekeepers in local cultures. So, for example, maybe this is very often older men in particular cultures that maintain and guard cultural values. Maybe we need to compromise in this kind of bringing together of local cultural values with international norms. Let's see what our speakers have to say. I'm going to turn first of all to Mr. Roy. So can you briefly outline some of the key issues from an international perspective on this issue, please? Maximum 7 minutes. Thank you.
Thank you, Marie. I know Marie very well, and I know she will enforce the 7-minute time limit very strictly, having worked with her for many years. So I will try my best. You've asked a difficult question, and the topic is a difficult one. It's a challenging one. But I think there are ways forward, and there have been some clues in the speakers and the speeches that have gone before in terms of how we can tackle this issue. I'm from Penal Reform International, and we are an international non-governmental organization that works on reforming criminal and penal systems worldwide. So this is not an easy task for us, and as you can imagine, we often get asked these questions about what is acceptable, what can be applied, what are some of the difficulties, and why should we even bother? Because we already have our systems, we already have our traditions, cultures, and as Marie said, where do you fit into all this? Why should we listen to you? Let me suggest 3 reasons why I think, or 3 ways in which we can address this issue, and I'm sure my other colleagues on the panel will further elaborate on some of these points. The first is at a philosophical level, and I think we need to tackle it at that level, because these are not simple issues about just laws or legalistic sort of interpretations of what is written down, but it has to deal with what I call our common humanity. As human beings, we are citizens of the world, and we share certain values, certain common understandings of what is needed, of what is good, what is bad, and children across the world, I suggest, just as adults, understand these values as well as any of us. So I think our common humanity both demands and requires us to take an international approach to the issue of justice, the enforcement of justice, and the issue of juvenile justice in particular. Just on the philosophical theme, I think there are 2 other points I would make. The first is that human rights, or the discourse on human rights, has evolved over the years. So what we see today, or what we take for granted today, or what we understand today, is not necessarily what we understood 50 years ago. It's certainly not what we understood 100 years ago, and going further back, we see that things were very different. There has been evolution, and things which were acceptable 150 years ago are simply not acceptable today. These changes have been brought about through collective action, with great sacrifice, and with a lot of effort on the part of a lot of people, not only lawyers, but also activists, students, children, our parents, and all those who have sacrificed quite a lot in order for us to be where we are today. So human rights has evolved, and some of the concepts, some of the issues that we might take for granted at the international level, we still need to understand that it's still evolving at various societal and cultural levels. The other point to make is that a lot of what we have at the international level is also aspirational. I don't think there is any country in the world that can put up its hand and say that we have fully implemented, for example, the Universal Declaration on Human Rights. It's one of the great documents of the 20th century. But it remains an aspirational document and something which we want to really sort of see as a goal towards which we will move as human beings, as international society. And therefore, we need to have a goal and we need to have these aspirations. And therefore, from my point of view, I think having standards, having internationally set standards are very important because it gives us something to aspire towards. So that's at the philosophical level. At the policy level, I think there is a lot still to do. There are unresolved issues, unresolved questions which still have to be dealt with. And it is not just at the local or national level that some of these issues are coming up. They're also there at the international level. So let me just mention a couple of very important issues that we are grappling with at the moment. For example, the issue of how many children are in detention. We simply do not know. And this is something that we need to urgently address. And to help us do this, I'm pleased to be able to announce that a global study on children deprived of liberty has now, a resolution to this effect, has now been accepted by the United Nations. And as we speak, there is discussion about how we will move forward on implementing this global study. At a policy level, I think this will be an enormous step forward in helping us identify what are the areas of juvenile justice that we need to properly address. The third level at which we want to address this is what I would call practical and what Marie called hands and feet? Hands. Okay. So practical is essentially about spreading knowledge, improving capacity, and encouraging stakeholders who are involved in these issues to really understand, appreciate, and internalize some of the discussions, some of the concepts, some of the issues that we grapple with and which we often want to explain in more detail and to people and stakeholders who might find it difficult to understand this. I think one of the best things, and I'm going to end on this, one of the best ways in which we can move the international discourse forward is through having binding standards which will encourage states to actually raise the level of human rights compliance. And I use the word binding because sometimes when we have guidance, it's often dismissed as being not something which as being idealistic or not something which can really be enforced. And therefore, from my perspective, I think there are still standards which we want to see being enforced, particularly around abolition of the death penalty, which unfortunately is still used for children, and we want to make sure that this is abolished once and for all globally. We want to see more action on ratification of conventions against torture and the optional protocol to the Convention Against Torture, because that gives us access to prisons, to detention facilities, and allows us to improve conditions for children who are in detention. And of course, we want to see fuller and complete implementation of the Convention on the Rights of the Child. Thank you.
Thanks, Nikhil. So if we could wait till the end for the applause, thanks. We are under great time pressure. So, Justice Ali, in Bangladesh it's taken 7 years, but you now have the juvenile justice aspects of the Convention on the Rights of the Child incorporated in national legislation. Congratulations. And you're now involved in implementing this with judges around the country. So what are some of the challenges involved in this implementation process, and how do you overcome these? Thank you.
Thank you, Mary. Good afternoon. I will take only 1.5 minutes, plus a few minutes of extra time. Problem is very simple. Now, as I see it, the people here today are all the converted. And the world outside is a hostile one, particularly towards children who are in conflict with the law. The problem is one of attitude. But we have the macho superiority of adults over children because they are small, because they are powerless, and because they are vulnerable. And not just men, women too, I dare say. Children should be seen and not heard. that was the Victorian attitude. Believe it or not, it still exists. Victorian attitudes in England may have gone, but they do still exist in the rest of the world. Now, that hostile attitude permeates through to judges. Judges and magistrates who deal with children in conflict with the law in particular. And that's because they come from a stratum of society where they are the better off. But sadly, through their work day in and day out, they see who are criminals, bad. They need to be dealt with. They need to be put behind bars. They need to be punished. Now that's the attitude that we have to deal with. They forget to consider that children are children. They forget to consider that their children are possibly the privileged ones, and those who come before them are the less privileged because of their background, because of their poverty situation. Now, this attitude or these attitudes run across religious bounds, racial and economic borders and cultural divides. Basically, they come everywhere. Now, what we have to do is impress upon the authorities that the international norms have been thought out by people who are engaged with how the world should be run, how the children should be treated, and we should take them on board. Now, as Andrew Breakoff said this morning, the judges are in an advantageous position. That is how I feel also. We can influence society. I managed to do that in 2006 in a case where I suggested that we ought to deal with the international instrument CRC, and we ought to incorporate that within our law. With the help of UNICEF, we got that on board. We had the cooperation of the ministries. We had the cooperation of the then head of the governments who were helping us to realize our goals of helping children. Now, the problem then arises is how to implement the law. We have the law. The provisions of CRC are incorporated in it so far as we could get them in there. But what we need is still the political will to implement. Right now, we don't have the rules to implement the provisions which have been introduced, including family group conferencing, alternative dispute resolution, and so on. And what we need most of all is raising awareness of those people who are dealing with children so that they get over that attitudinal problems. The problem, they have to realize that these children come from a background where they don't have the benefits that we had. They have to realize that the children need to be treated like children. Now, what do we need to do? We need to have training. The judges are still not aware of the background of the children. And they are really taken aback by the numbers of children who are committing crimes. And I tell them, look, you deal with criminals day in and day out. You don't see any good people. What would happen if your sister came to your house tomorrow and said, her son's been taken away by the police? Would you not do something about it? Would you not consider that the son may not have done something wrong, but he may have been under peer pressure to do something which has landed him in a problem? You would think about it then. Why would you not think about it in the case of the child from the street? So what we need is to be aware of what the situation requires. But then we have the unfortunate sensationalized problems, incidents, the one, for example, in Delhi. That is leading now to perhaps changing of the rules. The age is being reduced from 18 to 16. And sadly, Dhaka will probably follow Delhi. We have to get out and away from these attitudinal problems. And that's why I say that the international community should get together to make sure that the international instruments, they may not be absolutely applicable in every sense to every case. But at least we should get the benefits, the beneficial aspects into our laws, into our systems, so that we can deliver to our children, who are, of course, our citizens of tomorrow. If we can get good citizens from our children, we will have a productive nation. Is that not for our benefit? I'll stop here. Thank you.
Thank you, Justice Ali, for using less than your allocated time. So personalisation reaching at this heart level, so very interesting. You also mentioned how this crosses, a lot of these issues cross racial, religious backgrounds and so on. Mr. Abu al-Zulof, it's not a religious thing necessarily. This touches on some of the challenges in Yemen. For example, the mixing up of culture and tradition and religion on the part of judges. Can you give us an example of how this manifests itself and your top tips for overcoming these types of challenges? Thank you.
Yeah, thank you, Mari, and I will try to stick to the 7 minutes as well. I will start with the small, brief story when UNICEF asked me to go to Libya to provide training for our NGO partners. At that time, this was almost 3 years ago, on child rights violations monitoring. And when I started the training, it was the same day when al-Qaddafi was assassinated, when they captured him alive in Libya. And when I gave them an introduction to international humanitarian law and about those who are protected under IHL, including civilians, women, children, and those who are unable to fight anymore, then they started asking, does this mean that al-Qaddafi, despite the crimes that he committed against his people, was he protected under international law? I told them, of course, there's no difference. All human beings that are, maybe they were fighters, but are unable to fight anymore, they became prisoners of war, they are protected under international law. The same thing, and they said, no, we disagree with this. There should be exceptions. But unfortunately, of course, I told them no exceptions under international law. The same thing, this is around 3-4 years ago, happens with me almost every month, every week when I get in contact with law enforcement authorities. Every child, no, this is different story, George. You don't know what he or she did. She did 1, 2, 3, 4, 5. And that's why she should be punished. He should be punished. He has to be executed. And this is, for simple, I can say 3 key reasons around this. One of them is that the mixing of the cultural norms with the Sharia issue. But it has to do with the cultural traditions first. Secondly, the concept of the child and childhood in the MENA region. How we understand children, how we define children. Are they really social actors and subjects of rights within our system? No, I can tell you. Look at the penal laws, the criminal procedures law. You will not find the provisions that they are entitled of rights. And thirdly, the concept of child in relation to how they define children. What is the age of majority and the understanding of this definition in our culture. Now, good practices on how to overcome these challenges in the application of the international norms and standards. First, I think we should take always into consideration our implementation that we be participatory. All the stakeholders should be involved, their own vision, their own ownership, their own understanding, how they want to do things, not how we impose these things on them. National consultations, including with children, is always very important. And thirdly, the evidence-based advocacy. And I have a small example about child marriage, for example, with the National Dialogue Conference in Yemen around this. And I was discussing and talking about the impact of child marriage on the girls. And when a woman, they brought a woman who is a physician and to convince me that child marriage is not harmful to the girl's health. And after the discussion, I went to meet with her and discussed with her how many years you studied to become a physician. She said at least 10 years. And I told her, do you think you can do the same if you were married at 10 or 11 years? And this was the starting point that she is now a strong lobbyist on, against child marriage and to have 18 as a minimum age of marriage in Yemen. I'll talk afternoon maybe in more details in the after with the workshop around this, but I say yes, we can. It's possible to apply international norms in different legal systems, but the question is how to implement it. We should look at the socio-economic development as overall in every system and every country, how the notion of childhood is perceived by all people and stakeholders, and in our training and capacity building, we should focus on perceptions. Yeah. I agree with my colleague judge there, but the question is, how can we change the perception of judges? Because every time they will keep telling me, George, but this case is different. We tried in Yemen to implement alternative measures program to deprivation of liberty, and all judges agree. They agree that deprivation of liberty should be a last resort. But when we go to practice, we find no, punishment is the first resort. And deprivation of liberty is the first resort. How to change the approach? Now we should work, and we experience this. I cannot speak a lot around this experience now, but when we experience this in our work with judges on their own perceptions and their own understanding, how they can apply these principles and norms within their judicial system, it appeared to have better results. In the morning, my colleague Anne Grandjean talked about the juvenile justice as a human rights, of course, but also when we look at the overall, all rights are interrelated. And in any context, the family, even in the CRC, has a responsibility. And if the family is unable to take its responsibility in upbringing and protecting the child, the state should intervene and hold accountable and fulfill their obligations. And in many situations, when you see the absence of the family, the absence of the state, the child become a victim, and from a victim, the whole system is dealing with the child as an offender or as a criminal that should be punished. And in this situation, when we work with judges, they take just this part of the whole story, which is the crime. But they don't talk about where was the state when this crime happened, where was the family, what is the socio-economic background of the whole case. Thank you very much.
Thank you. Thank you. So interesting. So we can't just work with legislation, although this is one part of the puzzle, that we need this social change, the holistic, bigger picture as well, which leads me nicely on to our final speaker here. Judge Tomonu, in New Zealand, you haven't been working with your judges on the legislation. You've been working on influencing the process within the existing system. And a lot of international trends that we have been talking about here today on restorative juvenile justice in particular are actually derived from local indigenous cultural practices, in particular Maori traditions in New Zealand, which is your area of expertise, and also First Nations in Canada, which have given us some family group conferencing, sentencing circles, and so on. But in spite of this, interest internationally in the kind of the Maori practices, I understand that the work specifically addressing the overrepresentation of Maori children and young offenders is relatively recent. So could you please kind of briefly set the context and the underlying principles around this work for rangatahi courts, why you chose to work with these processes rather than with the legislation, and lessons learned which might be useful for other countries. Thank you.
Tēnā koutou katoa. Greetings, everybody. Ko hekurangi te maunga ko ea pūteo o ko Ngāti Porou Tiwi. My mountain is Hikurangi, my river is Waiapu, and my tribe is Ngāti Porou. As far as lessons learned are concerned from the rangatahi courts, where this will end up exactly 7 minutes from now is simply that process is just as important as substantive outcome. And that's where this discussion will lead. Next Friday, the 6th of February, will be the 175th anniversary of the signing of the Treaty of Waitangi in New Zealand, where the tribal leaders in New Zealand entered into an agreement with the Crown, the British Crown, and rights and obligations were agreed. And what it also did was it brought the British common law to New Zealand, and it replaced Māori law. As a result of the last 175 years, there have been various policies that have led to the overrepresentation, and assimilation is essentially the key policy that has led to the loss of language, the loss of culture, and we have a large proportion of the Māori population now who lack a sense of cultural identity. The New Zealand population, as Judge Andrew Beecroft pointed out, was 4.6 million people, and of that 14% or thereabouts are Māori. So there is an issue with the number of young people who are Māori who are in detention centres in New Zealand. 68% was the figure Judge Beecroft talked about. That gives some context to why we have gone down the track we've gone down, because the rangatahi courts are essentially about process. We haven't changed the law at all in terms of bringing the rangatahi courts into existence. We've worked within the existing law, but we have certainly changed the way that we deal with young people. One of the issues that we've had to grapple with is this idea that you can have a culturally neutral justice system where in fact there is a dominant culture and an indigenous culture, and the system is monocultural. The legal system is monocultural, the legal system is monolingual. And that was the position in New Zealand from the signing of the Treaty of Waitangi in 1840 until 2008. In 2008 there was a great deal of judicial vision involved, and Judge Beecroft was really at the forefront of this, along with our Chief Judge at the time, Russell Johnson, and more recently our Chief Judge at the moment, Jan-Marie Doog. That vision was all about sensing that something needed to be done, and the right thing needed to be done in terms of this idea of making our process more culturally appropriate for the young people who were from these Māori backgrounds. Now, when I began my talk this morning, or this afternoon, the way I began in the Māori language was what we call a pepeha, which is simply a greeting, a traditional greeting, outlining where we're from and who we are. And that's the type of pathway we try and set our young people on, because many of them who come to our court who are Māori do not have the language and do not have the culture. And so we sow seeds by encouraging them to learn that type of greeting, because that is the type of greeting that any Māori in any traditional ceremony or situation will stand up and give that particular greeting to say who they are and where they're from. Sir Apirana Ngata was one of the greatest leaders of Māoridom in the early 20th century, and his little note that he wrote to his niece back then, he didn't expect that the words of that note would continue on through the generations and would end up being spoken about at a United Nations conference, because it was a private communication between this great Māori leader and his niece, and it was words of wisdom and advice. And he said, "E tipu e rea mo ngā rā o tō ao. Grow up, my young niece, in the days and times of your generation. Ko tō ringa ki ngā rākau e te Pākehā, and extend your hand and apply the technology of the European settlers as sustenance for your physical needs. Ko tō ngākau ki ngā taonga o tipuna, hei tiki mō tō mahunga. Apply all of the treasures that have been handed down by your Māori ancestors and display them with pride. Ko tō wairua ki te atua, nāna ne ngā mea katoa. And as far as your spiritual needs are concerned, give them to the greater power." Now, those words are the underlying philosophy of what we're trying to achieve with the Rangatahi Court, because many of you probably will recognise that it's the here and now that matters to the young people we're dealing with. They are existing very much in a vacuum, and the sense of belonging, the sense of history, the sense of ancestry is something that we can provide by taking them on this journey through their culture. As far as lessons learned are concerned, as I said at the beginning, process is just as important as substantive outcome. But in order to achieve change within process, it does require certain elements to come together. First of all, judicial leadership, as I said. Secondly, stakeholder buy-in. There needs to be, within the youth justice community, a sense that this is the right thing to do, because in that way there'll be support. And finally, the community needs to own what you're attempting to achieve, because we've found the reason why there are now 12 rangatahi courts in New Zealand is because when the first one started in 2008, communities around the country, tribes around the country, approached Judge Beecroft and myself and said, we need this particular type of cultural process in our courts. And so that's where we are today. Kia ora.
Thank you. So just some reflections there. It seems we've come full circle in many ways. We are drawing on the treasures of the past, living in the present, trying to kind of draw together different strands of the best of all worlds that are available in different cultural contexts. But we also have this vision of the future, this aspiration of these international standards that should be binding, and the way that we work together is through this personalisation, working directly with people, tapping into what's important to them as a starting point, and not assuming that, that we know how it should be done. So I just wanted to come back. We just have about 5 more minutes left. It seems we've heard this morning about the systems approach. Like, yes, it's great. We need to be doing ongoing training with judges to help them not just initially, but how they apply all of this actually in practice in these cases where they come to you and they say, but this is different. I have to be harsh. I have to be strict here. Yes, we need this training. We need ongoing training. We need evidence-based advocacy. We need to be doing all of these things. How is this possible? For example, UNICEF has a framework called the Protective Environment Framework, and they identify 8 elements which a lot of you have touched on already and this morning as well. Legislation and enforcement is one of those elements. There's also government commitment, including allocation of budgetary resources. There is beliefs, attitudes, traditions, practices that we've talked a lot about here. Open dialogue with civil society and the media. Capacity of those in contact with the child, so families, professionals and so on. This is where our training comes in. The life skills and capacity of the child themselves. Basic and targeted services are needed, and we need monitoring and oversight. So if all of these things are needed, we are unlikely to be specialists in all of them. Is there a better way that we can come together, exchange these experiences, learn more from the rich traditions and cultures, and how we can move forward? Nikhil, from an international perspective, briefly.
I think we need more expert dialogues like this, so then we learn from each other and we begin to sort of reflect on what's going on in different countries, different cultures. But I think on a more serious note, I think the way international standards are developed, as we all know, I think you mentioned at the beginning, Mari, about sort of top-down, and sort of imposition. But I think over the years we've got better and better at developing international standards. And if you look at how it's done now, and I've been involved in a few such efforts, there is a real process of consultation across countries, across regions, across cultures, and we do try and bring on board different perspectives, so that when we do come out with a document or a guideline, standard, convention, it genuinely tries to capture the various strands of thought, the various strands of legal processes, because don't forget, even at a legal level, you've got, common law, you've got civil law, you've got Sharia law, you've got different traditions already. So when you try and come to some sort of agreement at the international level, you've got to take all this into account. And I think the great strength and success of the Convention on the Rights of the Child is precisely that it speaks across cultures, across countries, across regions, and really one of the reasons you have to ask is why have so many governments ratified this convention? Because it actually speaks to people in a way in which they feel, this is something that they can get behind. Yes, I know there are big challenges in terms of implementation, but if you just have to look at the contrast with the record and ratification, for example, of the Convention Against Torture, and you begin to realize that somehow the CRC has captured the imagination of states. The challenge now for us is getting on with the implementation.
Okay, thanks, Nikhil. I should point out that 3 of our speakers here are also doing workshops, and you will have the chance to discuss with them in a more interactive way throughout the week. Please do grab them during coffee breaks and lunch breaks. Sorry, guys, I'm just ruining your coffee breaks for you there. So very interesting. So we have something aspirational, universal. No culture that I know of intentionally sets out to harm children. Okay, we do have these very universal values that we can tap into. Culture is not static. We've heard that the human rights movement is not static. We're evolving. We're getting better at our communications and development of tools. Culture is not static. My mother's culture is certainly not the same as mine, for example. Michael Corriero yesterday, in One Generation, going from a tenement building to becoming a judge. Culture moves on. What role do we have as judges, influential people working in NGOs, devising policy? We have a role in helping to shape that culture, drawing on the best of the past, present and future. So I would just, to tie up quickly, remind that the preamble of this wonderful document, the Convention on the Rights of the Child, does actually say that we will do this work taking due account of the importance of the traditions and cultural values of each people for the protection and harmonious development of the child. In the current geopolitical situation, with increasing concerns around international and national security, a hardline approach to conflict with the law, we need to be even more creative, even more innovative and sensitive in finding ways to address this head, heart and hands of individuals, spreading ripples throughout the waters of change, so that we can, drawing on the Geneva Declaration of the Rights of the Child in 1924, as mentioned yesterday, humankind owes to the child the best that it has to give. So we really need to come together with our creativity, innovation and dedication to these universal values. So we have not had much time to discuss this complex issue. Please do speak with our panel throughout the week. Thank you very much for your attention. And I did try to learn this in the languages of the panel, so shukran. Relatively easy. I'm going to get the Maori wrong, please excuse me. Mururu koe? Close, thank you. Okay. And Tomake Danyabada, thank you. And thank you, Nikhil. Thank you very much, everybody. Yeah, I said that one first.
Excellences, Mesdames, Messieurs, une matinée fort intéressante se termine. Nous avons constaté que malgré la diversité des cultures, les préoccupations se ressemblent. D'où l'importance d'échanges comme ceux que nous avons entamés ce matin et que nous allons poursuivre tout au long de la semaine. Un autre moment d'échange également important est celui qui va suivre, le repas de midi. Je vous rappelle également l'inauguration des expositions de dessins d'enfants et de photographies qui aura lieu à 2 heures dans cette salle même, un événement au cours duquel la parole est aux enfants. Quant à nous, nous nous retrouvons dans cette salle à 2h30 pour les présentations par les délégués nationaux de la politique de prévention en vigueur dans leur pays. Je vous souhaite un très bon appétit. Merci.
Vamos por el buen apetito. Oye, qué malo el traductor de español.